Is it okay to name a minor as a beneficiary on a life insurance policy, an annuity policy, whatever, a long-term care hybrid policy? No, it's not okay. It's not okay. By the way, folks, my name is Charlie Gipple. I'm the owner of CG Financial Group in chilly Des Moines, Iowa. CG Financial Group is your IMO for annuities, life, and long-term care, as well as so much more practice management stuff like this. I practice on a daily basis. I'm a CFP, a CLU, a CHFC, so I'd like to think that the information I give out to you fine folks is more than just product-level stuff. I love the walking brochures out there. I'm not a walking brochure, although I love to talk product, but I digress there. It's not okay to have a minor as a beneficiary. Why? Because there is just as easy as a beneficiary designation as writing down the child's name. It's just as easy, but it's better from a legal standpoint. Let me back up and say this. Children in pretty much any state in the country that I know of cannot legally own property, right? So say, if I have a life insurance policy and if I name my 14-year-old son as the beneficiary, what's going to happen if I pass away and he is still under the age of 18, under the age of majority? What would happen to those assets? It would go through the court system. The judges, the attorneys would have to determine who ultimately is the custodian of that money, because Matthew cannot get $1 million check. He's freaking 14 years old, okay? Well, that's great, Charlie. So what are you going to suggest? So, I have a single mother making 30 grand a year who wants a life insurance policy, so that when she passes away, her kid, her 5-year-old kid, maybe has a potential to go to college or whatever, that life insurance policy. Then what's the alternative? She goes and buys a $2,000 revocable trust. That's a lot of money for her, right? Nope, has nothing to do with trust. Now, trust can be the best way to do it, but it costs money and it takes time. Some people don't want to spend the time or the money for that matter. So what's a just as easy process as writing in Matthew Gipple? It's an UGMA or an UTMA, Uniform Gifts to Minors Act, or Unified Transfer to Minors Act. It depends on what state you're in. And let me explain what it looks like. It looks like this. It's as simple as this. I would go to the beneficiary section on the life insurance application, and if I wanted to do this UTMA thing, which is much better than naming him specifically the beneficiary, and I would fill it in, it would look something like this. Disclaimer, different companies have different wording requirements, but here's kind of a common wording requirement. The name of the custodian. So you're specifying, not a judge, not an attorney, you're specifying on the beneficiary form, should you pass away while the beneficiary is still a minor, who do you want to be the custodian? So like me, maybe I will put my mother's name. Name as custodian. As custodian for Matthew Charles Gipple. Born, you put in the date of birth, under the state of Iowa UTMA. Under the state of Iowa UTMA. And what that will do is, as well, what I just said you do, is you are predetermining who that custodian would be as long as Matthew is under the age of majority, and that would be my mother in that example, because that's what I specified on the beneficiary form. Then once he turns age of majority, the money is his. That is the better and just as quick of a way as just putting in his name, but that's certainly a better way than just naming him directly as the beneficiary. Hope that helps.